Good afternoon. We're delighted that you've been able to join us for our first ever Pan-Caribbean conference. We do, however, appreciate that you have limited time in your busy schedules and that creeping Zoom fatigue is ever present. With that in mind, we've devised some bite-sized hot topics, sizzling tasters of our thinking on the issues of the day. Our first speakers, well known to you all, are Ed Cumming, Sarah Bayliss and Andrew Holden. They've gone all poetic on us with some Dylan Thomas. Here they are to explain why.
Well, good afternoon. Our first topic concerns issues that a lot of members of Chambers are encountering, both in the context of corporate disputes, where there's a battle engaged for control of a business empire, and in the context of trust disputes, where there's a battle for influence or control in a trust structure. And that topic is the sorts of challenges that arise where there are suggestions that a key figure in a business structure or a trust structure is losing or has lost capacity. And that can, of course, give rise to particular problems where you have a fiduciary or a company in the Cayman Islands or the BVI or another offshore jurisdiction, and the courts to which they would ordinarily turn and themselves are inevitably fairly remote from the key individual in question. On the trust side of things, for example, trustees and other power holders may be accustomed to acting on the instructions, so-called, of a patriarch or matriarch. And such patriarch or matriarch may hold important powers, even, including veto powers, under a trust instrument. But the trustees or power holders might rarely have met them, if at all, and most of the contact may be through a family office. How can they be clear that the message they're receiving is in fact that of the patriarch or the matriarch? And that becomes a major concern if its suggested capacity is failing or has been said to have failed sometime previously. You might think some comfort or clarity could be obtained from the local court of the place where the patriarch or matriarch lives, the equivalent of the English Court of Protection. But those courts actually generally have very confined powers that are territorially limited and won't tiptoe towards questions affecting foreign assets, even before you engage questions about firewall legislation. And I'm using this way just to give you an introductory flavour of the sorts of challenges we want to get you thinking about and that we're certainly encountering with more frequency. And in that regard, I think we're encountering them increasingly because people are remaining active until a greater age than ever before. The key individuals in a lot of the sorts of structures which you on the other end of the camera are likely to have been encountering as having been set up since the 80s or 90s are now increasingly reaching the age that one might impertinently call a certain stage of life. And although they may at least be able to contemplate their own fallibility, they and those around them probably haven't wanted to give or give very much detailed thought to it. And above and beyond that, communication's so much quicker and more informal and less deliberate than ever before. And we're also particularly interested in this topic because although these issues are tending to give rise to disputes with increasing frequency, they're not actually the focus of all that much discussion amongst the legal community, either when structures are being set up or when litigators are talking about or thinking about what can go wrong and how those things might be tackled. And we're hoping to redress that, at least to a certain degree today, albeit we're conscious that in just 20 minutes, we might be posing more questions than we are definitive answers. But the hope is that forewarned can be forearmed. So to kick off the discussion and to illustrate further the challenges we're talking about, we wanted to outline, to begin with, a very short and hopefully very simple scenario inspired by a couple of recent cases we've been involved with, and then to see what Sarah and Andrew make of the position if we allocate them to opposite and opposing sides. So the scenario is this. There's a trust company in the BVI or the Cayman Islands. It holds all the shares in a BVI or Cayman holding company for a business empire in Hong Kong and an investment portfolio. The board of the holding company comprises the Hong Kong resident settlor of the trust, who has auspiciously just celebrated their 88th birthday. The trustee is accustomed to being told of the settlor's wishes by the family office, and that office is run by one of the settlor's two children, their daughter, and like her brother, she is a beneficiary of the trust. The daughter's recently suggested that last year, the settler passed wide-ranging appoint-all powers to her as a successor in the event he lost capacity. And she also says the settlor either lacks or at the very least has fluctuating only capacity. The son gets wind of some dealings with the underlying assets of the trust, in particular in relation to an African mining venture, which he thinks is surprisingly favourable to the daughter and surprisingly unfavourable to him. And he's on the warpath, and he's spoken to Andrew to try and find out a little bit more about what his plan of action might be. So, Andrew, what's he going to do?
Well, he's not happy, as you say, and he's not happy because Sarah's client seems, behind the scenes, at various levels in this structure, to have been exercising a baleful influence in circumstances in which my client's father has historically exercised a wide range of powers and functions under this structure. And the powers and functions that he exercises are actually surprisingly wide-ranging. He's got, as you say, appoint-all powers, and his appoint-all powers extend in the usual fashion to the removal, replacement and appointment of trustees, and also veto powers in relation to trustee dispositions. They also permit the direction of trustees to make distributions. My client's dear old father also was in the habit of expressing wishes to the trustees through his letters of wishes, and he inhabited the position of the enforcer of the purpose trust that holds shares in the PTC. And underneath the structure, as you said, he sits on the board of the trading company. So he's in a position of quite wide and important power in the structure. But unfortunately, Sarah's client seems, through methods that seem underhanded, certainly to my client, to have put herself in a position of speaking on behalf of my dear old father and using his vulnerable position, can I say, his, dare I say it, failing memory, his loss of executive reasoning capacity, so that his decision-making has become increasingly poor in recent years. And undue influence seems to have been brought to bear upon him to cause him to sign documents which he never would have signed had he been in his full capacity. And had he had his faculties, he would plainly not, for example, have taken any steps to prefer my client's sister in relation to the management of the underlying company. So something is going deeply wrong here, I'm afraid to say. And so what I'm going to be doing is advising my client that we need to be taking some proactive steps here to stop the rot and to make sure that the fiduciaries who are in control of this structure are jolly well aware that something underhanded is happening behind the scenes. Now, plainly, my advice will depend on the jurisdiction in question, and we may have to come on to look at the new BVI legislation in relation to firewalls. But taking my advice in turn, I'd start by looking at the trustee, because the trustee in the middle, holding these powers to make dispositions, is in the capacity of shareholder of the trading empire, ultimate shareholder. And I'm not happy that there is any suggestion that the trustee's powers might be used to change the balance of power in relation to the ownership of the company. So what my client is looking at is, well, the immediate thought is injunctive relief. An injunction to stop action being taken by the trustee on the basis of purported directions being given on behalf of my client's father, which are really being directed at the control or subject to the undue influence of my client's sister. I'm also suggesting to the trustee that any wishes that they may be receiving purportedly from my client's father which are unusual or outside of the norm. Unfortunately, they don't seem to be sharing them with me because they say letters of wishes aren't disclosable. But I can tell them that from what I know about my father's position, he would never be undertaking the steps that seem to be happening at the level of the trading company. And so something has gone deeply wrong. And I think I'd be advising my client to invoke the equitable jurisdiction of the court in the trust jurisdiction to restrain any actions being taken on the basis of these directions or these wishes on the basis of quite clear authority in Jersey and Guernsey that allows the court to hold the ring pending a determination of the substantive issue. The other thing I might be telling my client to do is to scare the life out of the trustee by putting them on notice that if they do happen to take any steps in purported compliance with these directions, then it will be they who is liable for the consequences of that action, because they are now on actual notice that they have a settlor, a power holder, who is of no, or at the very best, dubious capacity. And so really, that and a few other things to put the cat among the pigeons.
So Sarah, is he going to get away with that?
Well, I don't know about that. One of the things that the son doesn't appear to have mentioned to Andrew is that he hasn't seen his dear old dad for the last 10 years, whereas my client has been running the business with him. So I think Andrew's in a position that everything he says is absolutely what one would want to do if they had the right facts. My instructions, perhaps unsurprisingly, are somewhat different. My client's been working with Dad for some time with a view to taking over the business in due course.
That was almost right. I think what you meant to say was your client's been working on Dad for some time to take over the business in due course.
Well, perhaps if that's what I'd meant, I would have said it, but never mind that for the time being. He wants to take it a bit easier, so he wants to give my client some more responsibility. One of the difficulties we now have, although we're not about to share such information with Andrew, of course, is that it would have been a lot better if we'd been consulted, if our advice had been asked for, while there was still no doubt at all about capacity. If that had been done, we could have made sure there were medical reports all the way as needed, particularly in relation to momentous decisions. And we would have kept, if I'd had anything to do with it, the trustees fully appraised of Dad's medical condition from time to time. We might also have obtained a Hong Kong EPA, because that's where the family lives, in favour of my client, which would, of course, then assist her getting involved in any proceedings on behalf of Dad that might kick off in other jurisdictions. Unfortunately, that hasn't happened, and Andrew has very sensibly, if I may say, advised his client to get in amongst and make as much trouble as quickly as possible. In those circumstances, I'd be inclined to advise my client to make an emergency application under the mental health ordinance in Hong Kong, with a view firstly to endorsing the steps taken to date, and for orders pending determination of the capacity issue, for my client to continue Dad's business on his own behalf, including by way of the powers now vested in her, and to conduct any legal proceedings on his behalf. It is to be hoped that such orders would be of persuasive authority, well, not authority, but would be persuasive in front of the BVI and the Cayman courts when they decide what they want to do about appointing an ex-friend under CPR 23 in the BVI or Order 80 in Cayman. One of the attractions of this course is that recent decisions before the Hong Kong court seem to be quite heavily influenced by the English approach to capacity under the Mental Capacity Act 2005 in the UK, which is all about essentially enabling people with fluctuating capacity or some difficulties with capacity to carry on with the decision-making process insofar as they can, and certainly to take their wishes into account. That's something my client is very keen to see continues in relation to her father. We'd want to try and think ahead to see whether there's any basis to contend that the proceedings that Andrew's no doubt about to get kicked off in Cayman, the BVI, whether we can argue that the appropriate forum for those is also Hong Kong, given the proceedings already on foot there. But supposing for these purposes that's a tricky sell, then I think it would be wise for my client and to consider whether it will be wise, to the extent that she can be involved on behalf of Dad or indeed on her own behalf, to give undertakings or agree to injunctive relief in those other jurisdictions, providing that the business can continue while any underlying proceedings are determined. While Andrew's frightening the living daylights out of the trustees, I think we're going to cosy up to them like mad and reassure them that proper steps have been taken to support Dad throughout and give effect to his wishes, and show them everything that we've got on that. We might also make clear in correspondence to Andrew's professional client that the appropriate forum for the determination of what steps should be taken to assist Dad in the management of his affairs it is always going to be Hong Kong, irrespective of any shiny new firewall provisions that might be in effect or coming into effect, because those don't in and of themselves supplant the normal application of the forum conveniens principle. And I think those tuning in from Cayman will probably be familiar with the Trident case, in which Mr. Justice Caveley makes precisely that point. So that would be my initial advice, and then standing by to hear what Andrew might get up to next and respond to that.
Before he jumps down your throat on firewalls, what if your cozying up to the trustee works so well that the trustee is very keen to go along with your no doubt excellent plan to extract value from a diamond mine in Africa that you've got all sorts of private interests in, and decides they're going to ignore Andrew's client? And not only that, but you manage to get a firm in BVI or the Cayman Islands, whichever jurisdiction it is, to trot up to Andrew's injunctive relief hearing and say they're there on behalf of Dad. They've got authority to act on behalf of Dad. They've got a one-page medical report. It's only so short because it had to be produced so quickly, saying that so long as you speak to Dad before lunchtime, he's perfectly lucid and can give instructions in respect of the trust. and because of the time difference, they've been getting all their instructions by getting up in the middle of the night and taking it all very, very seriously. Is that going to cause problems for your approach, Andrew?
Well, what I want to say is that when we are dealing with the question of the capacity of a power holder under the trust, it is not the law of the local jurisdiction which is going to apply. Under this firewall legislation, it is the law of the BVI which is going to apply. And the Trustee Amendment Act 2021 is very clear. It amends to provide for a definition of persons internal to a trust, including protectors, enforcers, everybody in that category, and dear old father in that capacity. His capacity has to be judged, I will be saying, under the law of the BVI. Otherwise, what you are doing is you are having an indirect, you are indirectly applying a foreign law to a question which, under the conflicts rules, under the Trustee Amendment Act, applies exclusively BVI law. Now, whether I'm going to succeed in that or not is a different question, but certainly I am submitting that the new regime, which applies to protectors and enforcers and so forth, subjects capacity issues to the law of the trust jurisdiction in the BVI.
And there may also be issues building on that with whether the Hong Kong court would be prepared to expand out the questions it was considering beyond the ones under the mental health ordinance and into questions that concerned a trust and potentially concerned documents that were executed a year or so previously. But what about the situation where you've got someone turning up saying, I'm here for Dad and I can get instructions at certain parts of the day, and Dad is resolute and clear as to what he's done in the past?
Well, it is an issue that's... Sorry, go on, Sarah.
I think you've got you've got issues with fluctuating capacity under those circumstances, haven't you? Because the regimes, not all the regimes that you're going to be operating under are going to be sympathetic to that state of affairs, nor indeed are they going to have legislation which enables the court to do very much about it. Even though under the mental capacity legislation in the UK, the structure is very much designed to assist people with fluctuating capacity, make what decisions they can. CPR 21, the provisions for appointing litigation friends, work on the basis that you either have capacity or you don't. CPR 23 and the BVI and Order 80 in Cayman are exactly the same. So it makes it very difficult for the court to come to any kind of view that allows Dad still to participate. I think there's another bear trap, at least one other bear trap in the scenario that Ed proposes, in that if what my client is interested in, consistently with my instructions, is making sure that everything is in apple pie order, what she is going to want to do is supply the trustees with information so that they can make proper and independent decisions that will stand up, rather than just rolling them over to do what she wants, which might rather play into Andrew's hands.
As we hit up against our buffer of time, did you have any very quick last comment you wanted to make beyond that, Andrew?
No, just that fluctuating capacity is an increasing issue. I think in this context, I would be looking at the extent to which my father, bless him, can continue to exercise fiduciary discretion, if that's what he has, in circumstances where he has an admitted fluctuating capacity, and that might be my next angle of attack on behalf of my client. But certainly it's an issue that is cropping up ever more frequently in practice, and I don't think our 19th century tests for mental capacity really address it. So it's going to be something that crops up more in the future.
And on that note, And the final comment that there is a looming Court of Appeal hearing in England, which may or may not be totally revamping the approach to capacity, certainly when it comes to testamentary capacity, and that leaches right through to all the other questions, because of course capacity, there's no such thing as capacity full stop. It's always capacity to do something. That's all we have time for, but there's a lot more we might want to say, and do get in touch if you've got any questions or interesting experiences you've had in this area. Thank you very much.
Thank you very much, team. We're now going to turn to a very 21st century problem brought to the fore by internet banking, the push payment scam, what it is and what can be done about it. Oliver Assersohn and Emma Hughes are going to help us with that idea.
Thank you very much, Stephen. I'll just try and share my screen. Mine and Emma's talk, as Stephen said, is titled Vanishing, Thieves is All Lost. And in our 10 minutes or so, we intend to set out 4 potential lines of attack that might assist to get back what's stolen if a thief disappears. And we're going to do so in the context of authorised push payment fraud, one of the most common types of fraud around. And as everyone knows, APP fraud is where a fraudster tricks a payer into pushing a payment to an account controlled by fraudsters. And just to give one example of a case I've had recently, my client was liaising with his solicitor to purchase very expensive residential property. In the course of various email exchanges with the solicitor, the fraudster managed to hack into the solicitor's email account, divert messages and take over the chain of correspondence. And after a few days of this, purported to provide new payment details for the solicitor, in fact, his bank details overseas. And when the client sent the large amount of money to purchase Sherwin's property to the fraudster and not to the solicitor, it quickly was dissipated to the 4 corners of the earth. When my client called the solicitor to ask about the purchase, the response of the partner's secretary, and realised they didn't have the fund, was, I won't say what the dots were, it's happened again, which, as you can imagine, was a helpful piece of evidence in the subsequent claim against the solicitors. But the sophistication of this type of fraud typically lies in the fact that the fraudster will skillfully interweave the content of previous genuine emails and communications into their own fraudulent communications. And so in the case I've just mentioned, for example, the fraudster wrote lots of boring emails about the contents of the survey and so on to lull the purchaser into a false sense of security. So what to do? And I've headed this slide alternative routes of attack because everyone listening in has no doubt heard talks or else dealt themselves with applications, not pharmacal relief or under Bankers Trust jurisdiction, or even following CMOC in 2018 for injunctions against persons unknown. And my Emma's talk isn't about those, and proceeds on the assumption that for whatever reason, those natural, obvious, but important lines of attack have resulted in a dead end for whatever reason. And so my first possible alternative line of attack is to bring a claim against the receiving bank. And I might think that the law here was settled, but there's been a very significant recent development in England which might have changed the position. In 2019, the Contingent Reimbursement Model Code, the CRM code, was introduced, and an updated version was published this week on Tuesday. And that's a voluntary code that a number of the leading banks have signed up to that provides that they will, in theory, compensate customers in the case of APP fraud. And if they don't, ultimately recourse is to the financial ombudsman. The scheme is largely aimed at consumers and their important limitations. For example, the transfer has to be in sterling and between UK accounts. But for reasons I'll go into, the code could be used to broaden out the duties owed by receiving banks at common law. And the code has some expectations that are not really that surprising, like firms should act in a way which reduces the occurrence of APP scams. But there's some arguably wider duties than would exist at common law that might be useful in a civil claim. And I'm limited in time, so I'll just give a couple of examples. But first, receiving banks, should take reasonable steps to prevent accounts being used to launder the proceeds of APP scams. And other examples, so receiving banks, here the bank of the fraudster, must take reasonable steps to detect accounts which may be or are being used to receive APP scam funds. And up to now, the leading case on the duties of receiving banks is a first instance English High Court decision, Abu Rama and Abakar, 2005, which was subsequently appealed, although not on this issue, and I've given the citation at the top of the next slide. And in that case, the English High Court refused to follow a Canadian case called Stangl and held that a payee's bank does not owe a duty of care to a non-customer originator of a funds transfer to pay money received only to the beneficiary identified in the originator's instructions, or to clarify any discrepancies in those instructions as to the beneficiary's identity with the originator. And in coming to that conclusion, the court relied on 6 factors, and I'd argue at least 2, arguably more, have been affected by the CRM code. And again, some limited time just to focus on 2 of these. Just looking at Roman numeral 5, a bank has a huge number of potential payers who can remit monies without significant control by the bank. That's true, but that hasn't prevented wide-ranging duties being voluntarily accepted under the code. Roman numeral 6, the imposition of a duty of care in relation to such persons would in practice impose burdens on banks and significantly hamper their efficiency. Again, whilst perhaps significant burdens are imposed, most large banks have now accepted those burdens in respect of large swathes of their customer base. To impose duties on banks in this way would require a departure from this first instance decision, but arguably the CRM code does potentially open the door to doing just that. And the relevance of the code to banks' duties is something that I understand banks are concerned about. It's been considered in a very recent decision in the context of sending banks, so in the APP fraud example, that's the bank of the innocent party, in the case of Philip and Barclays Bank that Emma will deal with when discussing the duties on sending banks, and which is a subject of appeal. I'm not suggesting this line of attack is a slam dunk argument by any means, but if recovery by some other route is not possible, it might at least be a way to mitigate against an otherwise impossible position. The second line of attack, transactional lawyers. Since so much of APP fraud stems from data breaches, it's worth considering whether or not a claim could be brought against the person responsible for the data breach. So in the case example I mentioned at the beginning of the talk, the solicitor whose systems have been hacked and thereby allowing the email correspondence to be intercepted by the fraudster. And the claim could be framed for a breach of the implied term to exercise reasonable care and skill, or for negligence, or where applicable, any relevant data protection law. And whilst this obviously presents an opportunity for us litigators, it also poses a risk to solicitors' firms, especially those with significant transactional practices, because if their client's data is hacked by reason of a failure of the solicitor systems, the solicitor themselves could potentially end up being liable. In conclusion, naturally, justice demands that the true villain of the piece, the thief, should be liable wherever possible. But where this isn't practicable and there isn't a straightforward route to recovery of the money, and there often isn't, the arguments I've mentioned may help the client become whole again and recover the money. So Emma is now going to speak on duties of sending banks and other aspects of solicitor liability.
So as Oliver mentioned, I'm going to consider 2 further aspects of 2 further routes for attack, which might be available in these APP fraud cases. Both of these routes have actually been subject to recent decisions here in England. So they have cropped up, and it is worth noting that both these decisions have been the subject of some controversy. So starting with the third line of attack, these are the possible claims that might arise against solicitors who might be holding client money when the fraud is perpetrated. Now, the relevant case here, which has considered this fact pattern, is a case called Dreamvar and Mishkon Drea from 2018. In this case, a fraudster had posed as the owner of a registered property in London. The fraudster had instructed solicitors to represent him and to negotiate a sale of property. they found a willing and genuine purchaser, that was Dreamvar, who itself instructed solicitors Mishcon Durea to act on its behalf in the sale. Predictably, after completion, but before registration of title, the fraud was discovered, by which point the fraudster had vanished along with the rest of the purchase monies. Dreamvar then commenced proceedings against both its solicitors, Mishcon's, and the solicitors acting for the vendor. These claims encompassed claims in negligence and claims for breach of trust. Now, on appeal before the Court of Appeal, both claims for breach of trust succeeded. The claims in negligence were not so successful. At first instance, the trial judge had held that Mishcons had not been negligent in their handling of the transaction. In particular, the judge gave weight to the fact that Mishcons were entitled to assume that the vendor's solicitors had undertaken all necessary identity checks to satisfy themselves as to the true identity of the vendor. On appeal, that finding wasn't challenged, but Dreamvar sought permission to amend their claim to include a claim in negligence against the vendor's solicitors. Permission was withheld on the grounds that it could not be said that the vendor's solicitors had assumed a duty of care towards the purchaser. Perhaps the most interesting aspect of the decision, and the aspect of it which has been subject to the most attention since, is the court's finding that Mishcons was not entitled to be excused of liability under Section 61 of the Trustee Act 1925, which applies here, where a trustee has acted honestly and reasonably. Now, this did come as a bit of a surprise, given the court's findings that Mishcons had taken all reasonable care. But really, the driving force here and what the court placed great weight on were the policy considerations, and that if no claim no remedy lay against Mishcons, there was every possibility that Dreamvar would have no relief. The court were also influenced by the reality that Mishcons had insurance, which covered them in the event of such a risk, and therefore they were better placed to absorb the loss. It is worth noting that analysis of Section 61 of the Trustee Act was actually a ground for Lady Justice Gloss's dissent on the appeal. She considered that it was not appropriate for the court to express sympathy for one commercial party over the other, simply because one had insurance and the other didn't. Now, the fourth line of attack is, as Oliver mentioned, claims against the sending bank, which has been the subject of a recent decision here called Phillips and Barclays Bank that was handed down earlier this year, and it's now on its way up to the Court of Appeal. In this case, Mrs. Phillips had been persuaded by a fraudster to part with £700,000, which she had paid out of her account here in England with Barclays to an account in the UAE. She had done so in the belief that by making the transfer, she was playing a critical role in an investigation being undertaken by the National Crime Agency, but that turned out not to be the position, by which point it was too late for the funds to be recovered. Mrs. Phillips then commenced a claim in negligence against Barclays, alleging that they had owed her a duty to take all reasonable care and skill when executing her instructions, and that duty extended to requiring the bank to have policies and procedures in place, allowing it to detect the risk of APP fraud and also safeguarding their customers against such a risk. Now, the bank obviously accepted it owed this duty of reasonable care and skill when executing their customers' instructions, but they disputed that duty could extend to protecting customers against the consequences of their own decisions. And the court ultimately agreed with that, and the claim was struck out. There were a few strands to the court's reasoning. Four are particularly interesting. The first was the finding that the duty Mrs. Phillips had pleaded would, if it existed, have the effect of emasculating the bank's primary duty of care to act on customers' instructions. The second was a concern that if such a duty existed, it would need to be supported by a very clear, recognised banking code, which the court considered was missing. The third was the court's concern that had such a duty been owed, it would make the banks liable to undertake urgent detective work, and they would be put in a position where they were having to second guess the commercial wisdom of their customers' decisions. The fourth strand was really the finding that, as between Mrs. Phillips and the bank, the instruction had been real and genuine at the material time, and so it was inappropriate to go back on that. Now, the case is on appeal, and it's due to be heard by our Court of Appeal earlier next year. It seems to me that there are two aspects of the decision which might prove particularly interesting and the Court of Appeal might elaborate on. The first is the scope of the Quinscare duty and whether there is any scope at all for it to apply in the context of individual customers, as opposed to a case where a company's agent instructs the bank to make a transfer in order to misappropriate company funds. And the second is the relevance, potential relevance here of the CRM code, which Oliver has briefly mentioned. Mrs. Phillips' transactions predated the code, but even now the code would not have applied because of the territorial restriction. But what was interesting about the judge's reasoning was his view that the code did not have a bearing on the content of the common law duty of care that banks owe. And in particular, the court reasoned that the very introduction of the code actually rather pointed against the banks having owed a comparable duty of care at common law. So those are the four possible routes of attack which might be available in these APP fraud cases. As Oliver says, by no means are these routes slam dunk options, but the law is clearly developing in this area, and it will be interesting to see how it unfolds going forward.
Thank you very much. That's a very interesting development. Pursuing a complementary internet theme, Stuart Adair is going to consider the fallout from email hacking. Who pays when money goes astray? Stuart, over to you.
Thank you very much, Stephen. Yeah, Oliver referred to it as APP, Oliver and Emma referred to it as APP fraud. In the context of commercial transactions between a buyer and a seller, it's often referred to as business email compromise fraud, or BEC fraud, and that's what I'm going to be talking about. This type of fraud costs businesses millions of pounds each year. It most usually involves the hacking of a seller's email account with a view to tricking the buyer into making a payment to a bank account controlled by the fraudster. Now, where the BEC attack is successful, an issue will arise as to whether liability for the consequent loss should fall on the seller, whose email account may have been hacked, or the buyer who made the payment to the wrong account. Now, there's little authority directly on this issue, but I'm going to share with you my views on where the answer may lie. Those views are developed on the basis of analogy with other areas of law, and also looking at authorities from other jurisdictions, and in particular the United States. I can only provide a very short overview of the subject in the limited time available, but there is a detailed handout which provides a more detailed analysis. Now, the start point is the contract between the parties. If the contract allocates risk of such loss to one of the parties, then this is likely to be determinative of the issue. Unfortunately, it is rare for a contract to allocate the risk of loss arising from BEC fraud. Most contracts will, however, stipulate the manner in which payment is to be made, and it's not uncommon for a contract to provide that payment is to be made to a bank account nominated in writing by the seller. Now, in Norman and Ricketts, a milliner in Bond Street wrote to Mrs. Ricketts in Suffolk stating that her account amounted to £142 and that the favour of a cheque within a week will oblige. Mrs. Ricketts sent a cheque in the post, but it was stolen in transit and cashed by the thief. Now, on the milliner claiming payment of the £142, the court held that payment had in fact been made by the act of putting the cheque in the post. Norman and Ricketts was decided in the late 19th century in the context of commercial use of the postal system. But the key question for us is whether a contractual term that payment is to be made to a bank account nominated in writing by the seller equates to the request for a cheque in the post in Norman and Ricketts. In Young and Grote, a husband, Mr. Young, who was going away on business, left signed blank cheques with his wife for her to obtain cash to pay employees or any other bills that arose. Mrs. Young required £50, 2 shillings and threepence to pay wages and asked a trusted clerk employed by Mr. Young to complete the cheque for that sum. The clerk did so, but in such a way that the figures and words could be easily altered. He subsequently altered the cheque so that it was drawn in the sum of £350, 2 shillings and threepence, and he absconded with the proceeds. It was held by the court that a customer drawing a cheque owes a duty of care to the bank to take care that it cannot be altered, and that by reason of Mr. Young's negligence, he was liable for the loss suffered. This duty of care was confirmed by the House of Lords in London Joint Stock Bank Limited against Macmillan. Although Young and Grote dealt with forged cheques and the relationship between a customer and his bank, rather than the position between a seller and a purchaser, there are clear analogies to be drawn. In both cases, there is a creditor-debtor relationship, and the creditor instructs the debtor to make a payment in accordance with written instructions, which instructions are then hijacked and corrupted by a fraudster. Now, it's interesting to note that in dealing with BEC fraud, the courts in the United States have also drawn analogies with the law relating to negotiable instruments. In the US case of Bo Townsend against Don Hines Ford, Bo Townsend agreed to sell 20 Ford Explorer vehicles to Don Hines for a price of $736,225. However, a fraudster hacked the email account of Bo Townsend and instructed Don Hines to make payment to a bank account under the fraudster's control. The district court granted summary judgment to Bo Townsend on the basis that Don Hines was in breach of the parties' agreement because it had not paid Bo Townsend for the vehicles. However, the United States Courts of Appeals for the Sixth Circuit set aside summary judgment, concluding that the district court had taken an overly simplistic view and had failed adequately to analyse this complex issue. It concluded that there had to be a trial to determine which party was in the best position to prevent the fraud. And in coming to this conclusion, the court referred to the law relating to negotiable instruments, including Section 406 of Article 3 of the United States Uniform Commercial Code. Now, that particular provision provides that a person whose failure to exercise ordinary care substantially contributes to the making of a forged signature on an instrument is precluded from asserting that forgery against the person who, in good faith, pays the instrument. Now, it's interesting that this provision echoes the common law principle in Young and Grote. Where a duty of care is owed in tort alone, or there are parallel duties in both contract and tort, the relevant contributory negligence legislation will apply. Now, in the BVI, that is Section 2.2 of the Law Reform Miscellaneous Provisions Ordinance. In the Cayman Islands, that is Section 8.1 of the Torts Reform Law. In this context of competing arguments as to which party was responsible for the loss, there is ample scope for findings of contributory negligence. Matters amounting to contributory negligence might include a failure to notice warning signs in fraudulent emails, such as poor English, or a failure to check or confirm payment instructions by telephone. Now, I must say that when I first started looking into this, it sort of frightened me to death, but I think there are some conclusions that can be drawn. It's clear that both buyers and sellers ought to be taking steps to protect themselves from losses resulting from BEC fraud by ensuring that their standard terms and conditions deal with the allocation of the risk of losses due to BEC fraud. They should be reviewing the security of their own email accounts, and they should be putting in place written policies and procedures to minimise such risk. Now, whilst there might be an argument that the principle laid down in Norman and Ricketts applies, the courts are, in my view, more likely to see terms requiring payment in accordance with written instructions as giving rise to a duty of care in respect of those instructions. There is, in my view, a very strong argument that the principle laid down in Young against Grote should be applied to payment instructions provided by email, i.e. there is a duty of care. Such an approach would be consistent with the approach that has been adopted by the courts in the United States of America. And finally, the doctrine of contributory negligence, in my view, will apply and will allow the court to balance the respective responsibilities of the parties for the losses suffered. Thank you very much, Stephen.
Thank you very much, Stuart. That was very enlightening. Now for what might be described as a power shower. Stephen Thompson, Hugh Miall and James Fennemore have some devious thoughts about powers seemingly improperly exercised. Over to you, chaps.
Thank you very much, Stephen. I'm just going to introduce the talks which Hugh and James are going to give, covering the important topic of ratification. And they're going to look at it from two different perspectives. Firstly, Hugh, considering it from a company law perspective, what happens when directors exercise powers which they don't formally have. And then James, from the perspective of the trustee situation in the like situation. In the company law context, it might be put like this. What if directors do acts as they might do every day, which perhaps because there's no quorum or because their appointment was defective or because sometimes there are no directors properly appointed at all, or even because they're actuated by improper motives, and they go on doing it for years, carrying on a business of a company in a way in which, if it's properly constituted, they should properly be able to carry it on. And then they find that everything has been, so to speak, wrongly done because it was not done by a proper board. What can be done in those circumstances to ratify those acts? Hugh.
Thank you, Stephen, and good afternoon, everyone. The situation that Stephen has just outlined and taken from that extract really deal with two types of problems that arise in the company context. One is an appointment issue. So where a director, for example, has not been properly appointed, you might have a defect in the exercise of a power. The next is where there's an excess of authority or where you act outside the constitution of the company. And then slightly separately is the situation where there's a breach of duty in the exercise of a power. I'm going to look at those briefly. But all of those situations give rise to issues of ratification. And when you're looking to cure or exploit the situation as an advisor, it seems to me it's ratification that you need to really consider. There are 3 points I wanted to make at the outset. The first is about the meaning of ratification. This is something I know James is going to touch on as well. But there are really 2 prongs to this. The first is ratification can be the adoption or the adopting of the exercise of the power itself, such as a transaction, where the authority or the appointment is defective. And the second is curing or absolving the wrongdoing of the person, usually a director, concerned. And those positions might overlap on facts. So one example might be that if a director, in breach of the self-dealing rule, causes the company to enter into a transaction with a company which he controls, in that situation, the director is acting in breach of duty and so might need absolution. But in addition, the company may need to decide whether it's going to adopt the otherwise avoidable act in relation to the second company, which can't escape the consequences because it's had notice. And in those circumstances, the first company might choose to do one or the other or both or whatever combination suits it in the circumstances. The second point, initial point, is to think about who is affected. And there's a distinction to be drawn, I think, between external and internal consequences of breaches or of lack of appointment and of ratification. So in relation to external issues, that's to do with the effects of the transaction on third parties and their standing with the company. And internally, of course, you're dealing about the relationship between the company and its directors. And then the third overarching point I'm going to touch on slightly later is about principles of agency, because unlike trusts, companies and their directors act on a principal-agent basis. And in my view, at least, that ultimately affects the questions of ratification and how one might finally deal with it. So moving on from those points, just dealing quickly with external issues. External questions are usually of limited relevance when it comes to defects in appointments or in the exercise of powers in company law because of statutory intervention. The first point is that an absence of capacity by a company nowadays will generally not affect the validity of the act in issue. And that is because there are various statutory provisions, both here and in the Cayman and BVI legislation, that to greater or lesser extent, depending on which act you're dealing with, abolish the ultra vires doctrine vis-a-vis third parties who are acting in good faith. A similar approach is taken in the cases of defective appointments or the subsequent disqualification of directors. And again, the provisions that I've spotted are on the screen. But essentially, the point is, if a third party is acting in good faith as a director, the fact that there is a defect in that appointment won't interrupt the validity of the act in question. There is a slight question mark, however, over the situation where there is no purported appointment at all, as opposed to some defect in the process. That is simply because I think there's an English House of Lords authority from the middle of the 20th century, I think, where a distinction was drawn between the situation where there's absolutely no attempt to appoint and a defective attempt. But in that case, the problem was the director himself was trying to rely on the rule to get around the invalidity, and the court obviously found that unattractive. For my part, I don't immediately see why principles of ostensible authority won't come to rescue a third party where the company has held out the person who wasn't ever appointed as being somebody with authority to act on the company's behalf. And similarly, if one compares it to another situation, if a director is appointed but acts beyond their actual authority, but has ostensible authority, then that would suffice, I think, to allow a third party to take the benefit of the act in question. So it's difficult to see why a different provision should apply elsewhere. Moving on to internal issues, which are much more common in litigation, and this usually concerns absolving the wrongdoing of the director themselves. Now, typically, one looks at ratification by resolution as the starting point, written or in the meetings. In England, at least, there is a statutory provision in the Companies Act which sets out steps for ratification which change the former law to mean that directors who are also members cannot vote on ratifying their own wrongdoing, and that is true of their associates. I'm not aware that there's a provision of that nature in the Cayman or BVI statutes, and so I suspect it is still a question of ordinary resolution in those jurisdictions. But nothing in the English legislation changes the question about the validity of unanimous consent of the members or acts incapable of ratification. And those are really the next points I wanted to just touch on, because unanimous consent comes up quite often, and yet it still causes quite a lot of confusion sometimes. The duomatic defence is very well known. The informal unanimous consent or authorisation, even in advance for a transaction, will excuse the director of liability. Just picking up on two or three points of nuance in relation to that doctrine that people often overlook. The first is that it's not enough that members would have ratified had they thought about it. That's Reader Jan of London. But there is a more recent Court of Appeal authority that suggests that if the facts mean that it would be unconscionable for a shareholder to remain silent in the face of an act being done, silence itself might be enough to provide the authorisation for the purposes of duomatic. And that's the Sharma and Sharma case. The next point is just to query whose consent is relevant. Now, obviously, we look at the members, but a case that Stephen was successful in the Privy Council last year, the Sitco case on appeal from the BVI Court of Appeal, the Privy Council decided that in reality, where it is the ultimate beneficial owner that takes all the decisions as regard relevant transactions, it is their decision which counts rather than that of the registered members. A very sort of common sense result, one would think. And then you've got the exceptions to ratification, which are quite well known. Ultra vires acts, of course, although they are rare now in modern companies because objects of companies tend to be unlimited nowadays, or acts which involve illegalities such as the unlawful return of capital. Acts which are frauds on creditors or minority shareholders or on the company itself. And then, of course, you cannot unanimously ratify a breach of duty by a director where the company is insolvent or doubtful solvency. Turning briefly now to just look at ratifying the act or transaction as opposed to absolving the wrongdoing. There the same question arises, well, who can ratify and on what basis? And I've just given some examples here. If a single director acts in excess of their authority, the question is, well, can the board ratify or does it have to be the company? And ultimately, the answer is, well, it depends where the power sits. If the board, properly constituted, would have power to do the act in question, then they can ratify. If not, it has to be the members. Slightly more tricky, perhaps, is where the shareholder or a third party purports to act for the company but doesn't have any actual or even ostensible authority. Can anybody ratify then? And in the Privy Council case of New Falmouth Resorts and International Hotels, the board said, well, yes, the board of the company can ratify if it falls within their powers, just like they could in the single director case. So again, the board can do it, or the members, depending on where the power sits. And then the final example is, well, what about acts which fall solely within the remit of the board under the company's constitution, but where the board has acted improperly? And this is what happened in Bamford and Bamford, where there was an unlawful allocation of shares by the directors in bad faith. But that power was delegated only to the board. And the argument was put before the Court of Appeal that the company, having had no power to do the act in the first place, could not have ratified it. Lord Justice Harman gave that pretty short shrift. And that was because ultimately, he said, a company acting by its members can ratify any exercise of a power, provided its inter is the company. And in my view, at least, that comes back ultimately to the question of the laws of agency, and explains that even where there are no directors appointed at all, a company can validate an actual transaction purportedly entered into. So in my view, just sort of practically speaking, it's always worth having in mind those sorts of issues when you're dealing with ratification of the two different types. And I can sort of hand back to Stephen to pick up where he started in what Lord Justice Harman said in Bamford. Over to you, Stephen.
Yes, well, we didn't give you at the beginning of this talk the full quotation because Lord Justice Harman answered the questions I posed to Hugh in general terms, in not as much depth as Hugh has gone into. The answer is that directors in those circumstances can, by making full and frank disclosure and calling together a general meeting or general body of the shareholders, obtain absolution, forgiveness of their sins, and provided that the acts are not ultra vires, the company as a whole, something that will be very rare these days, everything will go on as if it had been done all right from the beginning. And as Lord Justice Harman said back in 1970, that's a commonplace of company law. It's done every day. So that's a position under company law. What about the parallel situation in trust law, where there have been where there's been a defective appointment of a trustee or a trustee de son tour, or trustees have acted other than unanimously, the equivalent of not acting as a quorum on a company board. James Fennemore's going to tackle that parallel position for us.
Thank you, Stephen. Yes, so I'm going to talk about both of those situations in turn. So first, where there's been a defect with the appointment of a trustee, such that the person purporting to exercise the trustee's powers is in fact a trustee de son tort. And second, when there are multiple trustees, but the trustee's powers have not been exercised unanimously. And from the outset, it's conspicuous that the few authorities there are on both of these situations don't actually refer to one another. And it strikes me that in both situations, something very similar, if not identical, is in fact going on, and they at least need to be discussed together, if not wholly reconciled. So starting with that first situation, the trustee de son tort one. A trustee de son tort is liable to the beneficiaries in the same way as a true trustee, but it doesn't have the same powers as the true trustee. So if the trustee de son tort has purported to exercise trust powers before its defective appointment is discovered, those exercises will be void in equity. Unscrambling what they've done and perfecting the imperfections may cause a considerable headache. So what can the court do? Well, this has been considered in a sequence of decisions mainly in Jersey, although they've been imported in Bermuda as well. And it all kicked off with Ray B.B. in 2011. And in that case, quite strikingly, the Jersey court decided that it had a freewheeling power under the inherent jurisdiction to ratify a trustee de son tort's exercise of powers that it didn't in fact have. Now, there was no adversarial argument in that case, and there was no real discussion of whether this power actually existed. And it was fairly heavily criticised in subsequent commentary. So the Jersey court had another go in Ray Z Trust in 2016. And in that case, the court identified three different sorts of ratification that might be available. Only one of these, first, is technically true ratification in the sense that Hugh has been discussing. In relation to that first type, the court gave examples of a principal ratifying the actions of a purported agent or of a company ratifying the acts of directors. The court decided that it could not ratify dispositive powers made by a trustee de Sontor in this way, but it left the door open in respect of administrative powers. The second type is where the Void Act is just superseded by the true trustees exercising their powers again to produce the same conclusion. Now, there's no retrospectivity in this situation. They're just exercising their powers again. And the third type is what I've called the Three Wise Monkeys version of ratification, which is where the trustees simply seek a direction to leave whatever's been done undisturbed and not to spend too much time and trust money investigating. Now, this might produce a satisfactory conclusion in the right case, but it's not a true ratification of what has gone before. The court decided in that case only to exercise the second and third types of ratification, so not the true ratification that I've outlined at number 1 there. Now, ratification came to Bermuda in the Sea Trust case, and the court referred to Ray Z and seized on the Three Wise Monkeys form of ratification as its safest bet. So it made an order on the basis that it felt that the task of reconstituting the records of the trust over the last 20 years would be impossible, and the expense would be an enormous drain on trust resources. The Chief Justice noted that this didn't mean that he was relieving the trustee from liability for any breach of trust in respect of any of the powers that had been purportedly exercised whilst a trustee is on tour. That was rather at odds, though, with another decision in Jersey in the Ray O Trust case in the same year, because in that case, the court declined to ratify any of the trustee de Sontor's actions because it felt it first needed to be satisfied as to the merits of the decisions that had been made by the trustee de Sontor. But this would surely require precisely the same horrible investigative exercise that the trustee is seeking to avoid having to spend time and money doing, and which had been the basis of granting the relief by the Chief Justice in the Sea Trust case. And I think perhaps that what the Jersey court's doing here in the O Trust case is conflating the two different uses of the word ratification that Hugh referred to earlier, and was worried that by perfecting the imperfect exercise of a power, it could also be said to be curing or absolving any wrongdoing on the part of the trustee de Sontor if those exercises of power were in breach of trust. But as the Chief Justice said in the O Trust case, he didn't think that was correct. So the second sort of situation is one where there are multiple trustees, but a power has not been exercised unanimously. And that might happen in particular where one trustee is a professional and the other trustee is a layperson and becomes too passive. Now, the office of co-trustees is a joint one, and subject to a very small number of exceptions, trustees must exercise their powers unanimously and at the same time, although that timing requirement may be flexible to the particular circumstances. So starting from that principle, if the power has not been exercised unanimously, it's not been exercised at all, and the purported exercise is void. Given that is also the position concerning trustees de Sontor, it would be surprising if there were a difference between the way that ratification works in the two scenarios. And if there is a difference, then it ought to be properly explained and rationalised. There are very few authorities on this sort of situation, though, that are referred to in any of the academic texts, and I've set some of these out on the slide. The first two of these, though, don't actually establish any principle of ratification at all, as on the facts of both of them, it appears that the passive trustee was actually participating sufficiently at the relevant time. Libby v Kennedy, though, is more squarely on point. That was a pensions case where the trustees had to decide who to pay a death in service benefit to. The decision was made by two trustees. The money was then paid, and the decision was then subsequently discussed and approved at a meeting of the full body of the trustees. Mr. Justice Jacob actually found that the trustees' powers had been appropriately delegated, so the issue of ratification didn't in fact arise. He did, however, indicate that the full body of trustees would have been able to ratify the decision made by the two trustees alone. Now, his decision certainly looks like an approval of a proper retrospective ratification in this sort of scenario, but it certainly also could be rationalised as the second type of ratification referred to in the Z Trust case, where the full board is simply exercising its powers afresh, or even as a situation in which the board's approval is sufficiently soon after the initial decision that it's actually just part and parcel of the same exercise of the same power. Hansard and Hansard is a New Zealand decision in which it was held that a trustee can ratify transactions entered into by another trustee simply by signing off on trust accounts that reflected those transactions. But that judgment doesn't give substantial attention to the proper basis of a power to ratify, nor does it give detailed attention to whether it can be right to say that this would give the original act retrospective effect. So Lewin has consolidated these cases into this understandably slightly hesitant patchwork of a paragraph, stating a retrospective assent from one trustee purporting to approve what has already been done by the others without it will not do. But all the trustees may collectively ratify what has been previously done by some only of them, presumably on the footing that they're entitled to avoid the security of seeking to set aside the prior purported exercise only to exercise the power again in the same way. Now, this paragraph suggests that in this sort of scenario, trustees have a proper power of ratification such that they can act together to perfect prior acts taken by only one of their number. But as I've said, it might be surprising if this power were available in this scenario, but not in the trustee de Sontor scenario. And where the writers refer to seeking to set aside the prior purported exercise, it also sounds as if there's a suggestion that the prior exercise was merely voidable. But if it's not been done unanimously, it's void, and there's not a question of needing to set it aside. A possible explanation might be to argue that in this scenario, the minority trustees are purporting to act as agents of the whole body of the trustees, such that their acts can be retrospectively adopted under the principles referred to by Hugh. But this seems to me to be something of a stretch, and I certainly think you'd struggle to argue that a trustee de Sontor is acting as an agent in the same way. So if you're confronted with either of these sorts of scenario, it's clear that the courts have attempted to find a practical way through to reach a satisfactory conclusion if they can. But the specific position in each case needs to be carefully analysed, and you need to be clear what sort of ratification is actually being contended for. What unites most of the cases is a lack of adversarial argument. So if you actually act for a beneficiary who really wants the prior acts to remain void, the underdeveloped nature of the jurisprudence in this area may well provide fertile ground for being disruptive. And on that note, I'll hand back to Stephen.
Well, thank you very much, James, for ending on that interesting and practical consideration. I think listening to you both opine on the law in this area, it's interesting to see how some of the principles which might have been thought to have been to develop in parallel have diverged so much. But it's very interesting and illuminating for the two of you to scratch the surface of the question of ratification in a company and a trust law context. And with that, I'll pass back to Stephen.
Thank you very much. We finish with the light fantastic. Dancing their way across the stage are Bajul Shah, Nicole Langlois, and Timothy Sherwin. No more Samba time? What's going on, guys?
Good afternoon, everyone, and thank you, Stephen. For decades, the courts around the world have been inventive in assisting claimants in fraud claims. The Black Swan jurisdiction in the BVI or the TMSF case from Cayman are all testament to the court's inventiveness, or is that Stephen Moverley Smith's inventiveness, in assisting fraud claimants. But has the tide been turning? For example, in May of last year, we saw the ECSE Court of Appeal rule in Convoy Collateral that Black Swan was wrongly decided. Now, what we want to do in our talk, and I'm going to put up the slides just now, what we want to do in our talk is to consider whether the pursuit of fraud claims has become more difficult because of certain decisions from the court. So Tim will first consider the Byers and Samba case in which he has been involved and its impact on knowing receipt claims. Nicole will then consider knowing receipt in the context of real property. And finally, I will consider how recent cases show that arbitration clauses can disrupt the orderly conduct of fraud claims in court proceedings. So, Tim, over to you.
Thanks very much, Bajul. The Samba case was handed down earlier this year and deals with principally the law of knowing receipt. The facts will be relatively familiar to those of you in the Cayman Islands in particular, since it arises from the same series of unfortunate events as the Ahab litigation. The claimants were the joint official liquidators of a Caymanian company known as Sickle, which is obviously in liquidation. The director of Sickle, Man Al-Sanea, declared a series of trusts over shares situated in Saudi Arabia. They were in Saudi Arabian blue chip stocks, and those shares were in favor of the company. The company was the sole beneficiary. They were bare trusts. Now, what happened when the wheels began to fall off the bus in 2009 was that Mr. Al-Sanea transferred to Samba, a bank, a large proportion of the shares in order to discharge his own debts and some of Samba's debts. Now, Samba was debarred from denying unconscionable knowledge of the existence of the trusts as a result of a decision of the docketed judge, Mr. Justice Fancourt, resulting from their failure to give any disclosure. So it was a given that they had unconscionable knowledge for the purposes of the trial. And indeed, the judge struck out the majority of the defence in order to save for certain issues of law because Samba had totally failed to give proper disclosure. In those circumstances, there were three questions which were effectively pure questions of law or mixed questions of law and expert evidence for the judge to decide. The principal one was whether, as a matter of Cayman law, which was accepted by all parties to be the same as English law, whether the claim was bound to fail, the claim in knowing receipt was bound to fail if the company's rights in the shares were extinguished on transfer. Now, the reason that arose is because it was argued by the bank successfully at trial that the effect of Saudi Arabian law was that a transfer of shares totally wiped clean the pre-existing title. That is to say, the transferee got good title, which was utterly indefeasible. It couldn't be rectified by the beneficiary or similar under a common law trust or similar Saudi Arabian legal institution. So what was the answer to that question? Yes, the property must be trust property both before and after the transfer. Now, that is a new proposition that had never been decided before in any case. But the judge considered that title was the defining factor in these cases. And he therefore considered that if a transfer gives good legal title, then it also washes equitable title, even if, as the bank was debarred from denying, the transferee has unconscionable knowledge. He therefore said that it is true that liability as a knowing recipient will then depend in such cases on the law applicable to the transfer of the trust property. But of course, there's a question-begging element in that quotation, because his own finding was that in certain circumstances, the transfer causes it to cease to be trust property. Now, Mr. Justice Fancourt thought that that was the effect of the decision in Macmillan and Bishopsgate by Miss Justice Millett, as he then was, and approved by the Court of Appeal. But it's striking that, firstly, that's not what the defendant itself was in fact arguing. The defendant said there was no authority directly on point. But secondly, Macmillan and Bishopsgate was, properly speaking, a proprietary case. It was a case about tracing and not a case about personal equitable remedies at all. There's a further interesting point that arises from the Byers and Samba decision there, and that is a new distinction which the judge drew between two types of knowing receipt, so-called dishonest knowing receipt and what the judge called pure knowing receipt. Dishonest knowing receipt is knowing receipt where there is dishonesty, properly so called, and pure knowing receipt is where there is merely unconscionability. Now, if you can tell me simply and easily what the difference between dishonesty and unconscionability is in any given factual situation, I'll be very impressed. It's certainly not. They're certainly not two concepts which are easily distinguishable, but they now have quite considerable practical differences. In the former case, there is no need for a proprietary base, the judge seemed to say, apparently because the remedy would be fault-based, as in the case of dishonest assistance. In the latter case, the pure knowing receipt claims, the judge considered that a proprietary base must be established both before, during, and after the transfer. And therefore, this new distinction between pure and dishonest knowing receipt will turn on those very distinctions between dishonest and unconscionable behaviour, which can be so difficult to draw in any given case. That therefore gives an interesting example of what Bajul described as a potential turning of the tide, in that in this case, even where the bank was assumed to have unconscionable knowledge of the trust, they knew they were taking trust property without the permission of the beneficiary, there was still no liability found. That said, the claimants do have permission to appeal on all points in the judgment. The appeal will be heard in December 2021. It'll doubtless be a very interesting judgment. And so watch this space. Over to Nicole now to develop some more of the judge's considerations in Byers and the effect on different types of property.
Thanks, Tim. So in the next part of this talk, I'm going to be looking at how the issues that Tim has just been discussing played out in circumstances where the assets of the trust in question comprise land, and specifically land in jurisdictions which have a torrent system of land registration, or at least a modified version of this. Now briefly, a torrent system of registration generally adopts two principles. The first is the mirror principle, which is the principle that the register reflects or mirrors accurately the current facts about title. And the second principle is the curtain principle, so the principle that one doesn't need to look behind the certificate of title. But in practice, however, and as we shall see, the position is not quite as straightforward as that. Now, of course, you'll all be aware that both the Cayman and the BVI systems of land registration are both torrent systems. And in Cayman, the provisions are set out in the Registered Land Law in the 2018 edition. And in the BVI, they're set out in the Registered Land Ordinance of 1970. Now, the starting point for our discussion is a decision of the Privy Council on appeal from the Court of Appeal of the Turks and Caicos Islands. And that's the case on the slide of Arthur and the Attorney General. Now, the Turks and Caicos Islands also have a torrent system of land registration. And in fact, the provisions of the Turks and Caicos legislation are, in all material respects, identical to those of the Cayman and the BVI legislation. So in Arthur, it was claimed on behalf of the Crown that a government minister, in breach of fiduciary duty, had entered into a corrupt agreement to sell Crown land to Mr. Arthur at a significant undervalue. And Mr. Arthur had then sold the land on to a third party and made a substantial profit. So the AG advanced both a proprietary claim, and initially that was against the land itself, but subsequently it was made against the proceeds of sale. And he also advanced a personal claim against Mr. Arthur. Mr. Arthur applied to strike out those claims on the ground that on the true construction of the Turks and Caicos Statute, the RLO, his title to the land was good and indefeasible. So in other words, he invoked both the mirror principle and the curtain principle. But he was unsuccessful both at first instance and on appeal. And he then appealed to the Privy Council. Now, in light of the point that Tim's had just been discussing, it's interesting that the Privy Council noted that both sides appear to have proceeded on the assumption that knowing receipt claims, even though for personal relief, are properly viewed as a vindication of pre-existing property rights and are parasitic on those property rights, and so are inappropriate against a purchaser who takes free from the prior trust by virtue of the Torrens system in question. The Privy Council, however, went on to hold that on the true construction of the RLO, it was, in fact, open to the Crown to assert both a proprietary and a personal claim against Mr. Arthur as a constructive trustee on the grounds of knowing receipt. So in summary, what the board held was that the effects of section 38.2 and 122.3 of the RLO, and both of those provisions are mirrored in the Cayman and BVI legislation, was that a registered proprietor of land would take the land subject to the interests of beneficiaries in a case where the property had been transferred in breach of trust and the registered proprietor had dealt in bad faith. So in other words, in a case where it would be possible to establish equitable fraud. And the RLO also provided, Proviso 1 to Section 23, that the registered proprietor's absolute title was subject to any duty or obligation to which he was subject as trustee. And in the opinion of the board, the wording of that proviso did embrace the duties of a constructive trustee for knowing receipt. The Privy Council then also went on to hold that irrespective of the proper meaning and effect of sections 38 and sections 122 of the RLO, there was no reason in principle why the proviso should not in any event be construed as including the personal duties and obligations to which the transferee would be subject as a constructive trustee for knowing receipt. At first blush, therefore, the decision in Arthur seems fairly uncontroversial, in that the Privy Council held that on the proper construction of the statute, a registered proprietor who knowingly receives trust property takes his title subject to the interests of the beneficiaries. So in other words, he doesn't in fact acquire an absolute title, and he's therefore liable to a claim, a proprietary claim, but also to a personal claim for knowing receipt. However, on a closer analysis, the Privy Council's further conclusion that a personal claim would still lie irrespective of the proper meaning and effect of sections 38 and 122. So in other words, irrespective of a proprietary claim, could be said to leave open the argument that the Privy Council did not in fact share the party's assumption that a personal claim is always parasitic on a beneficiary's property rights. Now, it's a pity that Mr. Justice Fancourt didn't address this argument head on in his judgment, and it will be interesting to see what the Court of Appeal has to say about it. I think it's also possible that arguments that were run unsuccessfully in front of Mr. Justice Fancourt might yet be run successfully in a court in an offshore jurisdiction where decisions of the Privy Council are regarded as highly persuasive. So now I'm going to hand over to Bajul.
Nicole, thank you very much. I'm going to focus on something slightly different, and that's how arbitration clauses can impact on commercial fraud claims in court. Now, most commercial frauds are likely to involve a contract, albeit that the fraud allegation is often that the contract is actually a sham or an instrument of fraud. Now, if the contract contains a compulsory arbitration clause, then that gives the defendant a valuable tool. He can apply to stay the court proceedings on the basis that the dispute should be arbitrated. I've set out in the slide the various statutory powers that allow that application to be made. They're well known and well familiar. And whilst there are differences between them, all three have the same basic broad idea, which is that if legal proceedings have been brought in respect of a matter that is subject to an arbitration agreement, then the court, on an application of one of the parties, must stay the proceedings. And so the critical question in these sort of disputes is identifying what is the matter. And the legal test for how you identify what a matter is was definitively set out in an English High Court case called Sodowinski and Ruhan in 2018. An important case, not least because I was in it and we won, but also because it looked at all the previous authorities and synthesized the principles. And the key takeaway from that case is that what constitutes a matter is any non-trivial issue that's capable of constituting a dispute. You don't just look at the claim or the causes of actions that are brought by the claimant, but you need to consider the defenses and also the possible defenses to identify the issues. Now, an illustration of how identifying the key matter can stop a fraud claim from being pursued in court was demonstrated very recently in the English case of Republic of Mozambique and Privinvest, sometimes reported as Republic of Mozambique and Credit Suisse, where the Court of Appeal decision was handed down in March 2021. The facts are a little bit complicated, but in outline, the position was as follows. The Republic owned 3 special purpose vehicle companies that entered into supply contracts with the Privinvest companies. Those contracts were governed by Swiss law and had arbitration provisions. The SPVs borrowed money by way of loans from Credit Suisse and others, and the loan agreements were guaranteed by the Republic. The Republic's liability under the guarantees was over £2 billion. The Republic alleged that it was the victim of a fraud and that the supply contracts had been induced by bribery and they were instruments of fraud and sham. And so it brought a whole suite of fraud claims, such as deceit, bribery, conspiracy, dishonest assistance, etc. And it brought those against the lenders, Credit Suisse and the others, as well as the Privinvest companies and Mr. Safa in England in one set of proceedings. The Privinvest entities applied to stay the proceedings on the basis of the compulsory arbitration provisions. They also argued that under Swiss law, which governed those agreements, the Republic was also bound by the arbitration provisions. Now, the stay application failed at first instance because the judge said that the supply contracts were simply important background. The claims and allegations were not sufficiently connected with the supply contracts to fall within the arbitration provision. The Court of Appeal reversed that, and they applied the Sodowinski and Ruhan approach to the question of the matter. They said that that had to be approached broadly and not just from the point of view of the claimants. Importantly, the Court of Appeal accepted that it was a foreseeable defense by the Privinvest companies to all of the claims that they would allege that the supply contracts were in fact valid and genuine. And so a key question in the dispute, a key issue in the dispute, would be whether the supply contracts were valid and genuine. And that issue plainly fell within the scope of the arbitration provisions. And therefore, the court ordered a stay of the proceedings against the Privinvest companies. Even if the supply contracts were invalid, the arbitration agreements as separate agreements would still be valid. Now, the consequences of that ruling for the Republic are dire. They would now have to pursue claims in court against some defendants, but in arbitration against others. And it gets worse because the different supply contracts had different arbitration provisions, so potentially there would be separate arbitrations. And so the Republic faces the prospect of fragmentation, duplication of resources and costs, potentially limited discovery in arbitration, more cumbersome interim regimes, and the nightmare of conflicting judgments and awards. Now, of course, the Privinvest companies would say, well, look, this is simply the logical consequence of different compulsory arbitration provisions and the law's policy of giving primacy to arbitration for dispute resolution. And if you're advising a defendant in a fraud claim, it's always worth scouring the relevant agreements to see if they contain compulsory arbitration clauses, because that could render the claims in court dead in the water against you. But for a claimant, it certainly is not Samba time. Thank you very much.
Thank you very much indeed, Bajul. Well, thank you everyone for tuning in. I hope you found our sessions entertaining and enjoyable. Please share with us by email any thoughts you may have about what you've heard. Unfortunately, time doesn't permit a question and answer session now, but if there are any burning topics that you want to share with the speakers, please feel free to email them. We all, of course, hope that by next year things will be back to normal and we will possibly be able to come and see you in the Caribbean, enjoying your sun and sand. Meanwhile, we hope you keep safe and well and look forward to seeing you all again very soon. Thank you very much.